constitutional authority cannot be prevented from performing its constitutional duties for an indefinite period of time. Inclusion under paragraph 15 of the symbols order. The other test may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other test. To assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. What is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)b as well. When there are two whips appointed by two or more factions of the political party, the speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the speaker on whether a member must be disqualified under paragraph 2(1)b would also depend on the decision of the speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the house to prevent voting for granting leave to move a motion of no confidence. If the speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did